with Elder Care Law of Kentucky, and I'm doing this video. I'm getting asked a lot in my presentations. What's the difference between a revocable living trust that I've already got created and an irrevocable trust that I hear all these elder law attorneys talking about? And I've probably done some Google searches and learned all about these, and I really just can't understand the difference. Well, first, let me start out by saying, if you're over the age of 65 and you go to an estate planning attorney and they're recommending you do a revocable living trust, there's a good chance, a very good chance, that that's just not appropriate advice. So this video is going to try and help explain the differences and why it's not really what you need if you've been fortunate enough to make it past the age of 65. Okay, so we'll start with basics of a trust, kind of law school 101. What is a trust? So the best example, think of a trust as a bucket that you're going to put your money in. So I'm going to draw a little bucket here. Please forgive my artwork. Here's my bucket. Isn't that some good artwork? So we've got our bucket. Now every trust has to have three parties. Party number one has to be the settlor, also called grantor, also called trust maker. These are three words that mean exactly the same thing, okay? This is the person who creates the trust, funds the trust, and makes the rules of the trust. One of the rules of the trust is who is going to be the trustee. Another rule of the trust is who are going to be the beneficiaries. Now, legally speaking, unless you have a settlor, a trustee, and a beneficiary, you don't have a trust. Technically, you can create a verbal trust. If I give my sister $100 and say, "Sister, I want you to hold this $100 for my daughter. And someday I want you to give it to her as she needs it." And my sister accepts the $100. We've just created a trust. The money does not belong to my sister. It is for the benefit of my beneficiary, which would be my daughter. Now us lawyers, we create everything on paper and we sign everything, and everything's going to be formal. So the revocable living trust, the settlor funds the trust, okay? And they can also get the money out. So they put money in, they get money out. All right. So there's no lid on this bucket. You can carry the bucket from point A to point B. It's no different than having the money in your actual pocket. The point of doing a revocable living trust is simply there's two purposes. Avoid probate, which can be costly and a hassle for your beneficiaries or your heirs. And also to be more specific about how the money goes to your beneficiaries. So if you've got children or grandchildren, you want money to stay in trust, maybe you've got a farm or some property that you want to be protected for your beneficiaries over time, you can put all these rules in the trust, and the trust will hold that money pursuant to your wishes and distribute it in accordance with your wishes. For example, maybe you've got a disabled child. Maybe you've got a child who has a spending problem or has a tendency to get divorced on a regular basis. It's always better to leave money in trust to those children for their own good, to protect them from themselves sometimes. I always say the last thing you want to do for someone who has a drug or alcohol problem is to actually just give them money. You're just contributing to their addiction. So if you can leave money in trust to those people, you can actually help them without hurting them. That's the revocable trust. So there's no lid on this bucket. Money can go in, money can come out. There's really no value to a revocable living trust until after you pass away. Once you're dead, that's when this revocable trust becomes irrevocable. The lid slams shut. And now the money is protected and you avoid probate. But until you die, there's really no value in it. It's just peace of mind for after you're dead. Now, when I'm doing planning for my elder law clients, we're trying to protect money while they're still alive. We have to protect money from creditors, from from would-be fraudsters. Uh, we're trying to protect money, and most particularly from the nursing home and from the Medicaid Spend Down. A revocable living trust does nothing to help us with any of that. So the trust we want has to be irrevocable. Now, the revocable living trust, the settlor, which would be you, who the person paying the attorney to create the trust, you guys can wear all three hats. You've got your settlor hat, your trustee hat, and your beneficiary hat. You can be all three parties at the same time, until you die, of course. With the irrevocable trust that elder law attorneys create, the money can only flow one way initially. Okay, the settlor or the grantor cannot be the trustee or the beneficiary, because if you are a trustee or a beneficiary, the Medicaid agency, the state Medicaid agency says, hey, if you're the trustee or the beneficiary, you still own the property. You still have control of all the property in the trust. Therefore, we're going to count it as a countable resource. So you don't get any asset protection with the revocable living trust. With the irrevocable trust, we put a lid on the bucket, and then we're going to put a lock on the lid. Draw me a little lock here. The only person gets a key to the lock is the trustee. Okay? Now, typically the trustee is one of our children, a good friend, someone. It might be the attorney. It might be a bank. A lot of times there are a lot of banks and trust companies, investment companies will act as trustee over your trust. The downside to those guys, you have to pay them. But usually it's, 90% of my clients, it's going to be their son or their daughter who's already helping them with stuff anyway. So just for sake of argument, let's say that the trustee is going to be our kids, okay? So we're going to put kids. We trust them all. The only qualification for trustee is that they be trustworthy, okay? Kids are going to be the trustee. Kids are also going to be the beneficiaries, all right? For this example, we'll just imagine that however many children I have, when I die, everything, I'm going to leave it all to my children equally, okay? Now, once I fund the trust, okay, I'm going to fund it with money. I'm going to fund it with my house. Boy, I got some. If you think it's hard drawing on paper with a pencil, try it on a computer screen. So house, money, life insurance, investment accounts, anything non-qualified, meaning non-IRAs, non-401ks. 401ks and IRAs we never put in a trust because that would trigger a taxable event and would be a whole different can of worms to open. But we can pretty much put everything else in the irrevocable trust. Once we do it, we put the lid on the bucket, put the lock on the lid, trustee gets a key to the lock. Just like having a safe in your daughter or son's basement, you put all your money in the safe. If you ever need the money out, you can get it out, but your child or your trustee has to unlock the door for you to get your money out, okay? So in order to return the money to you at some point, the trustee takes the money out, and because they're also a beneficiary, they can get it, okay? They then turn around and give it right back to you. No different from them taking the money physically out of their safe and handing it back to you. This is how you can maintain access to your property. Typically, you're going to forego control and title. Title is irrelevant. Who cares what the title says? Who has access and control of the property are really what's important. Now, to protect your assets from the nursing home, it's very important to remove title because you can say, honestly, I don't own anything. Maybe I've got $5,000 in the bank or something that I keep just for my day-to-day expenses. But my house, my savings, the bulk of my property is going to be in this trust, but it's not in my name. So I don't have to claim it as one of my resources. Now, by doing this, now many people have heard of the 5-year look back. That applies in every state except California, who still has a 3-year look back. If we do this ahead of time, proactively, we make it 5 years before any of the spouses have to go into a nursing home, you now have options. you can now decide whether or not you want to private pay for a nursing home or not. And maybe you just want to private pay for 6 months or a year, just to get you into that really nice nursing home that you've had your eye on all this time and that you really hope you end up at, right? Wink, wink. Nobody ever wants to go to a nursing home. But the sad reality is some of us do. The older we get, the more likely it is we're going to go to a nursing home. So I believe that at age 80, it's around 50. It's around 50%. So it's like a flip of a coin, whether you're going to a nursing home. If you're married, you've got two individuals in a family, in a household, who each have a 50% chance of going to a nursing home. So now we've got a 75% chance that one of them will go. So it's doing estate planning, doing asset protection planning for anyone over the age of 65. I can't think of why you wouldn't do the irrevocable trust planning as opposed to just the traditional estate planning with the revocable living trust. Now, if you're 50 years old, you're still working, you're still at the peak of your earnings potential, you're still shaking and moving, buying, selling, trading, it might be a little early to start doing irrevocable trust planning. Maybe not, but probably, for most of my clients, they're not quite ready to start locking their savings up into an irrevocable trust. They're still in the accumulation phase of their life. They're not in the protection phase quite yet. So when I have clients tell me they've already had their estate planning done by an estate planning attorney, I'm immediately skeptical. I want to see the trust and I want to see whether or not it's revocable or irrevocable. If it's not irrevocable, they paid a lot of money for not that much value. The irrevocable trust planning costs a little bit more than the revocable trust planning, but the value is exponentially greater. You can think of this like an insurance policy. I've got a house that's paid for, whatever the equity is, couple $100,000 in equity. I've got savings, maybe I've got $50,000 to $100,000 in savings. I'm going to purchase an insurance policy in the form of an irrevocable trust from my elder law attorney. As long as I make it 5 years, I pay him once to do all the work. If I make it 5 years, it's 100% protected. So the risk that I'm insuring against is the risk of going to the nursing home, which is quite high because of my age. I've now protected all this value for the relatively low sum that I paid as a flat fee to the elder law attorney who did all this. Now, the prudent investor, the prudent planner is going to do this in their 60s, early 70s. Unfortunately, I commonly get people who, I just had a meeting this week with a couple that were both in their 90s. They hadn't even, and they had children from previous marriages. They had been married for 40 years, but they'd already had children in a previous marriage. And they hadn't even discussed who's going to get their stuff when they die. The discussion had not even taken place. And I got to laughing. I said, well, it might be time to think about that. Well, you're 93 years old. Maybe we want to think about what happens when we die. It's no longer something that's way on out into the future. It's knocking on our door. Now, theoretically, that applies to all of us. If you're religious, if you read the Bible, or if you've just been awake for any amount of time on this earth, you know that death can come for us at any time without any warning. So it's always something you should be thinking of, no matter how old you are. But certainly, if you've made it into where you consider yourself an elderly person, or others at least consider you to be an elderly person, it's time to start thinking about this stuff. So that's the primary difference between the revocable and the irrevocable trust. Now there's lots of different types of irrevocable trusts. The traditional irrevocable trust is created to protect money from the IRS, from the estate tax. Most of my clients don't have to worry about estate taxes, okay? The exemption is around $12.5 million right now, something like that. Not too many of my clients have to worry about that because their estates are less than $12 million. Now that law could change as I make this video. It is May 20th of 2023. If Congress can get together and agree on something and have the president sign a new bill, that number could drop dramatically. It could go back down to 1, 2, 3, 5 million, whatever they decide to make it, to where if your estate is above that amount, then you do have to worry about estate taxes. but the odds of them coming together and agreeing on anything right now are pretty slim. So for the time being, we got to deal with the law as it is written, as it's in place today, which is above $12 million. So that type of irrevocable trust is different from the asset protection trust that we're creating, because we're not worried about the IRS. We're worried about the nursing home and the Medicaid Spend Down. So I'm going to do some more videos talking about the Medicaid Spend Down and how that works. But for now, I just wanted to hit this one. This is a very general, surface level explanation of the differences, but I think it hits on the important points of what the difference between the two trusts are, and why, if you're above the age of 65, the irrevocable trust planning is what you really need, not the revocable. So let me type this in here. Irrevocable trust. Okay. So reach out to me if you have any questions. If you would like to have a consultation, you can go to eldercarelegacy.com, or you can just call me at 859-298-2150, and I'm happy to schedule a time for you to sit down, go over this. Or if you're already one of my clients, this gives you a good reminder, a good refresher of why you did an irrevocable trust instead of the revocable living trust. And most especially, if you're going to an estate planning attorney and they're recommending a revocable trust for you, have them watch this video, and if they don't agree with me 100%, you have them call me, because I can convince them, and I'll show them why I'm right and they're wrong. And give them the opportunity to argue their side, because again, my planning is specific for people over the age of 65. And if you're doing the same planning for a 50-year-old that you're doing for a 70-year-old, logic would tell you that's probably not right. There's no one size fits all. There's no boilerplate solution that can apply to everybody's scenario and be, it just makes common sense that it would have to be different the older you get, because you're outliving some of those risks. If you're in your 70s, it's really hard to convince someone that you're dying too soon, and you've certainly lived long enough to outlive the risk of becoming disabled before you retire. Most people are retired by the age of 70. So the risks are different, the problems are different, so the solutions also have to be different. Reach out to me. Thank you for this video. Hope you enjoyed it, and you have a nice day.